Well, good morning, everyone. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, April 14th, 2021. The time is 9:30 a.m., and I'll begin with a roll call. Good morning, Commissioner Lindley.
Good morning.
And good morning, Commissioner Janeka.
Good morning, Chairman.
Our commissioners are all present, and how about our General Counsel? Ms. Smith, are you there?
I'm here, thanks.
Good morning. And how about our Public Interest Counsel?
I'm here. Good morning.
Good morning, Mr. McWhirter. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. For those who are making presentations, please wait to begin your presentation until I or our General Counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you speak. And with that, I'd like to thank everyone for being present this morning. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Bosky Solutions for air quality standard permit for a concrete batch plant, registration number 152013. Representative Cook has requested to address the Commission, and Senator Powell has requested that her staff member also be allowed to read remarks to the Commission on this application. As a courtesy, the Commission customarily allows statewide elected officials and members of Congress and the Texas Legislature to address the Commission on items. However, the Commission may not consider those comments in its deliberations pursuant to Texas Government Code Section 2001.141, which requires the Commission to limit its consideration of any contested case matter to the evidence and matters that are officially noticed. So OGC recommends that we begin with Representative Cook and then Senator Powell's letter, and then begin oral argument. The applicant will present first, followed by the protestants, the ED, and then OPIC. By letter dated March 12, 2021, the applicant, protestants, the ED, and OPIC were informed that they would each be allowed 5 minutes for oral argument. The applicant may save some time for rebuttal as it bears the burden of proof on the application.
Thank you, Ms. Smith. And Representative Cook, I want to thank you for being with us this morning. And sir, the floor is yours. You might want to double check your microphone to see if it's muted.
I believe it's unmuted now. Is that correct?
There we go. Yeah, I hear you loud and clear. Good to be with you this morning. Thank you.
Thank you. Thank you very much for the opportunity to be with you as well. So thank you, Commissioners, for allowing me some time today. My name is Representative David Cook. I represent myself and the citizens of House District 96, and I'm here today to speak on Agenda Item 1, TCEQ docket number 2019-0665 AIR, and SOA docket number 582196473. I'd like to urge you to accept the Administrative Law Judge's proposal for decision and sign the proposed order denying the application of Bosky Solutions, LLC for air quality standard permit. And I believe that the Administrative Law Judge has done an excellent job of reviewing the facts and preparing the findings of fact and conclusions of law. And I respectfully urge the Commission to, again, come to the same conclusion and sign the proposed order. In the interest of time, I will keep my comments primarily to the proposal for decision by Administrative Law Judge Summerhays, who ruled that evidence showed that Bosky's application did not meet the application statutory and regulatory requirements for issuance of the permit for this plant. In her proposal for decision, Administrative Law Judge Summerhays determined that Bosky Solutions, LLC failed to demonstrate that their plant will comply with emissions requirements set by the Texas Administrative Code, the Texas Health and Safety Code, and recommend that TCEQ deny the permit application for the plant. In making her recommendations and denying the order, I believe the judge Summerhays properly relied upon the following evidence. Bosky failed to demonstrate that the plant will be constructed and operated in accordance with the emissions limitations of 30 Texas Administrative Code Section 106.261 and by reference Section 106.262. Also, Bosky failed to demonstrate that emissions from the sand used at the plant would meet the ESL for crystalline silica required under 30 Texas Administrative Code Sections 106.261A3 and 106.262A2. Next, Bosky failed to specify the application, the amount of cement dust that would be included in the total over 13.5 tons per year of emissions. Notice of the application was not provided to the presiding officer of the City of Fort Worth's governing body in accordance with Texas Health and Safety Code Section 382.0516B. Next, the emissions from the plant will not comply with all TCEQ rules and with the intent of TCAA, including the protection of public health and physical property. Based on the above findings and conclusions of law, the administrative law judge determined the application fails to meet the requirements applicable to the air quality standard permit for concrete batch plants 30 TAC section 116.610. It is vital that the TCEQ not dismiss the recommendations of the role of SOA in the resolution of disputes. In so doing so would risk undermining the purpose of SOA and the intent of the legislature in determining emission standards that protect the health and safety of all Texans. I also would like to add that the House Committee on Environmental Regulation has been referred multiple bills out of an abundance of concern by legislators that aim to better protect Texans against the harmful emissions caused by concrete batch plants. While one may argue that these plants are safe when properly operated and maintained, Bosky has not shown their ability to comply with the requirements of the application processes alone. And I ask you to consider what the consequences of Texans' health and safety should be, in fact will be, should Bosky continue their pattern of failure in more critical scenarios once the plant has been built. And finally, I just want to offer just a few additional comments, Commissioners, if I may, and that just specifically is within regards to what you see here. I mean, this is not just a couple of neighbors that have come out and complained. This is a full community that have come together and not only shared their concerns specifically, but they've done everything within their power to make sure that this concrete batch plant is not in their backyard. And I ask that you find and you sign this order denying the application, because these people not only put their blood, sweat, and tears in it, they put their money where their mouth is. It's difficult to go out and pass the hat to collect attorney fees, and that's exactly what these people have done to show you how important it is that you don't ruin their lives, their daily lives, in their neighborhood, their community. They have gone out and like no other purpose I've seen in my over a decade of service. Obviously, I'm a new state representative, but I have previously served in the role as mayor of Mansfield for about 12 and a half years, and I've worked with these people with regard to this particular proposal, and I can tell you it's a bad plan. There's a necessity with regard to these concrete batch plants, but this is not the place nor the time to approve this proposed application, and I respectfully request it on behalf of all those in House District 96 that you deny this application. And thank you for what you do. I know it's a very important role. It's very important what you do, and it's difficult decisions. I'm respectful of that. I too have those tough decisions on an hourly basis as we speak now. But thank you for what you do, and again, please deny this application.
Representative Cook, thank you very much for sharing your thoughts with us. Thanks for your service to our state. I appreciate you being with us this morning. We're going to hear next from Mr. Gary Jones, who I believe has a letter to read from Senator Powell. Good morning, Mr. Jones.
Well, thank you, Chairman. Can you all hear me?
Loud and clear. Thank you, sir.
Great. Thank you, Chairman and Commissioners, for allowing me to come address you all on behalf of Senator Powell. I'm Gary Jones, Senator Powell's Chief of Staff, and I'll be reading a letter into the record. I sent the letter to Megan yesterday evening, and I also sent it to the Commissioners and appropriate staff members as well. So if you need anything else on that, let me know, and I'll resend it. Yesterday, Senator Powell again sent a letter to the Chairman and Commissioners dated April 13th. She wrote, As the State Center for the site of the Bosque Solutions LLC proposed air quality permit 152013, I'm writing to reiterate my continued opposition to the proposed permit on behalf of my constituents. I continue to oppose this permit application because the plant will negatively affect the health of my constituents, as confirmed by Administrative Law Judge Joanne Summerhays in a November 2020 opinion on this matter. According to Judge Summerhays, in the findings regarding the crystalline silica emitted by the proposed plant, the quote, evidence rebuts Bosque's prima facie case that it has complied with TCEQ rules in regard to the limit on crystalline silica. The judge further went on to state in regards to the crystalline silica issue, Bosque, quote, failed to establish the application is protective of human health and safety. It is, end quote. It is well documented that prolonged exposure to crystalline silica can cause cancer, COPD, and kidney disease, according to OSHA. As public servants, we are charged with protecting the health and well-being of the citizens of Texas, not putting them in danger of breathing air filled with cancer-causing matter. I am gravely concerned that the crystalline silica emission, in addition to dust and other particulate matter, will cause long-term adverse health effects on the residents who live nearby the proposed plant. Some is close to 100 feet away from the emission source. Finally, I ask the Commission to take into consideration the continued work of the citizens of Mansfield opposed to this concrete batch plant, attempting to move into their residential community. On their own dime, these citizens have traveled to Austin and elsewhere to advocate for their neighbors over the past 2.5 years. These citizens are not looking for fame or fortune, but only ask for clean air for their families who have called this community home for years. My constituents in the entire southeast Tarrant County community will be adversely affected by the proposed plan, and I continue to remain steadfastly opposed to approval of this permit. Sincerely, Beverly Powell, State Senator, District 10. Thank you very much, Chairman and Commissioners, for allowing me to read this into the record.
Mr. Jones, thank you very much. We appreciate you being with us this morning. I also want to thank Senator Powell for her interest in this matter, for sharing her thoughts with us, and for her service to our state. Thank you again. I think we're now ready to turn to the applicant, who's represented by Mr. Larkin. Are you there, sir? You
okay, now.
There we go.
Good. Can you hear me well?
Loud and clear. Yeah, please go ahead and state your name and affiliation, and the floor is yours.
Thank you. My name is Pat Larkin. I represent Bosque Solutions, the applicant in this matter. Well, let me start by saying greetings and good morning to the commissioners and the council. The applicant requests that the PFD by the ALJ be rejected and that the permit be issued by the commission. The ALJ's PFD recommends against issuance of the standard permit, but the ALJ incorrectly found that the permit requires silica testing. The 2012 permit was not amended to require silica testing. An amendment under Texas Health and Safety Code 382.05195 and 30 THC 116.605 requires any amendment to a standard permit to go through public notice. A text change without notice is not an amendment. And respectfully, if the afternoon lunch receipt was dropped into the record, that would not make it part of the permit amendment. Second, a failure to test seems to have been turned into a presumption of harm, and that's not the case. Failure to test is not evidence of harm. It is a non-compliance with a provision which we think doesn't apply. Because the executive director testified that silica risk was actually analyzed and thoroughly analyzed when the permit was first developed, permit controls actually contemplate and include controls for silica. Thus, this rebuts the incorrect presumption of human health harm from any lack of testing. Finally, these new testing requirements and alleged risk arguments regarding silica were not referred by the commission, and protestants never requested addition of these issues to the scope of referred issues to be decided by the ALJ. Accordingly, the commission should reject the ALJ's proposed findings that there was a human health or other risk present and issue the standard permit to Bosque Solutions. I'll reserve the balance of my time for any rebuttal. Thank you very much.
Thank you, Mr. Larkin. And next up are the protestants, and I understand Mr. Friedman is with us this morning. Good morning, Mr. Friedman.
Yes, I'm here. Can you hear me, Chairman?
Loud and clear. Thank you. Go ahead.
Great, thank you. Good morning, Chairman and Commissioners. My name is Adam Friedman. I'm here on behalf of the protestants that live directly adjacent and very close to this proposed facility. And I just think it's interesting that the applicant's comments, there was no dispute that they're going to exceed the crystalline silica emission limit. There's simply just multiple arguments that the TCEQ should ignore that limit and should ignore those crystalline silica emissions. And before I maybe get into a little bit more of each of those allegations, which were briefed extensively in the exceptions and mostly in the closing arguments that were all rejected on multiple occasions, I'd like to take a quick step back and talk a little bit about how we got to where we are with the PFD that recommends denial of this particular plan in the application. From the very beginning, this application has been flawed with two major mistakes. First, the applicant checked the box that this proposed plant is not within the ETJ of any municipality. That was flat out wrong. They acknowledged it in depositions, in a hearing, and we had a motion for summary disposition, grant dismissal of the application based on the failure to provide the City of Fort Worth presiding officer notice of the application, which to this day has still not been provided to the City of Fort Worth. Second, and more troubling, in the PI-1S form, which is a required piece of the concrete batch plant standard permit application for a permanent batch plant, asks the question, did you demonstrate that emission limitations in 30 TAC sections 106.261 and 106.262 are met? And the applicant, Bosky, checked not applicable. And that, of course, in 106.261 is where the emission limit for crystalline silica gets pulled in to as a requirement for this standard permit. And the reason that's so troubling is because the direct consequence of that not applicable check mark is that nobody evaluated the harm to the protestants or the public health from those emissions. And as it turns out, as Representative Cook referenced, there's over 13 tons per year, a portion of which is going to be crystalline silica, and it's going to exceed the emission limit. So how do we know those emission limits apply? That's one of the main pieces of the argument that Bosky is proposing, that you shouldn't even consider those emission limits. The executive director does not take that position. They make very clear that they agree that those emission limits apply. They allude to the question of whether or not the standard permit was effectively amended with enough comments and public notice. That was briefed. That changed in 2012 when it took out the language. There was an exemption for those emission limits in the 2000 and the 2003 versions. That was affirmatively removed in 2012. That change was public notice. There were comments. There is no inadequacy in the change of that 2012 amendment. And if the commission wants to add that language back in, they are certainly at liberty to do that with a public notice and a rulemaking process with all the stakeholders weighing in. But that language was expressly exempt. There is no removed. There is no more exemption, which is kind of consistent with the protectiveness review that was done in 2012 to support that application, because that review never considered crystalline silica. And the witness for the TCEQ testified that these emission limits apply. He said, and I asked him, and that's reflected in, so you agree that the emission limits in the 106.261 do apply to permanent concrete batch plant standard permit? He answered, yes, sir. And that's reflected in the Ameritex application that was submitted into evidence. Yes, sir. And the Ameritex is important because that's a separate applicant that you guys recently had a decision on whether to grant a hearing or not. They contend they met the emission limits. They didn't check the box not applicable. So there is a way, there is a path forward. I'm running a little low on time, so if there's any questions, I encourage you to ask me so I can elaborate. But the bottom line is there is a path forward. Bosky can apply for an individual permit, and it can demonstrate that these emissions are safe and that crystalline silica will not cause a problem. That has never been done. As we sit here today, there is no technical support for a decision that the crystalline silica emissions will not cause harm, and that's the burden that the applicant has to show. That's issue number one. It was referred to SOA. Will this application be protective of public health? The ALJ clearly and correctly found it does not. And the protestants would urge and respectfully request the commissioners to adopt the ALJ's proposal for decision. I recognize there's a few modifications that could be done that the ED has pointed out with respect to how
That's time.
ESL, yeah, I understand. I'm sorry. I'll wrap up. The ESLs are referenced. There were some corrections that I don't think there's a problem that the ED has proposed, but the overall recommendation that this permit be denied until it is deemed safe ought to be adopted by the commissioners. And I thank you for your time. Thank you.
Thank you, Mr. Friedman. Colleagues, let me pause and just check in with you, see if you have any questions for either the applicant or the protestants at this point. Commissioner Lindley?
I do not at this point. Thank you.
Commissioner Janeka?
Thank you. Not at this time.
Thank you. Okay, let's hear next from Executive Director Staff.
Good morning. Can you hear me?
I can. Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Amy Browning with the Environmental Law Division, representing the Executive Director. With me and available to answer questions are Betsy Peticolas, also with the Environmental Law Division, and Don Nealon of the Air Permits Division. For the reasons discussed in the ED's exceptions as filed, the Executive Director disagrees with the ALJ's PFD and the recommendation to deny the permit application. The standard permit for concrete batch plants was developed through the rulemaking process, which included an extensive protectiveness review, which demonstrated that the permit would be protective for all applications that are approved for a registration to use this standard permit. The evidence shows that the technical requirements contained in the standard permit for concrete batch plants ensure that the emissions authorized by the standard permit will not be detrimental to human health and welfare or the environment. TAC Section 116.610A1 provides that standard permit applicants must demonstrate compliance with the emission limitations contained in 30 TAC Section 106.261 in certain circumstances. The standard permit for concrete batch plants, as it was initially developed, included a waiver from the requirements of 30 TAC Section 116.610. This waiver was included because, based on the results of the protectiveness review, the Executive Director's staff determined that operations complying with the technical requirements of the standard permit for concrete batch plants would also comply with the emissions limitations contained in Sections 106.261 and 106.262. Inadvertently removed from the standard permit for concrete batch plants as it was amended in 2012. However, the Executive Director's underlying determination that operations in compliance with the standard permit for concrete batch plants will also comply with the limitations in Sections 106.261 and 106.262 has not changed. Therefore, because the application meets all the requirements of the standard permit for concrete batch plants, the ED continues to support the determination that the registration, if issued, would be protective of human health and the environment, general welfare, air quality, and that the permit will not cause a nuisance so long as the plant is operated in accordance with the requirements of the standard permit. Therefore, the ED respectfully recommends that the Commission adopt the ED's proposed changes to the ALJ's PFD, findings of fact and conclusions of law and order, and issue the permit. Thank you, and we are available to answer any questions.
Thank you, Ms. Browning. Colleagues, any questions for Ms. Browning? Commissioner Lindley?
No questions, thanks.
Commissioner Janeka?
I'll hold off and wait for any further discussion. Appreciate it, Chairman. Thank you.
Thank you. Let's hear next from the Public Interest Council.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. After considering the evidence and the argument presented in this matter, including all post-hearing filings, OPIC maintains its position as articulated in its closing argument, that Bosque's application for a registration under the Air Quality Standard Permit for concrete batch plants should be denied. Preliminarily, OPIC will note that the facility is located in the extraterritorial jurisdiction, or ETJ, of Fort Worth. However, because Bosque incorrectly represented in its application that the proposed plant would not be located in any municipality's ETJ, Fort Worth was not notified of the application as required by the Texas Health and Safety Code. Previously, the Honorable Judge Summerhays granted summary judgment in favor of protestants on this basis and authored a proposal for decision recommending denial of the application. At the April 8, 2020 TCEQ agenda meeting, the commissioners deliberated this issue and directed SOA to proceed on the merits. After considering the additional evidence presented at the hearing on the merits, OPIC respectfully recommends commission denial of this permit registration. OPIC agrees with the findings of the administrative law judge that the record establishes that because the facility's emissions were not evaluated for compliance with all applicable emission standards, Bosque has failed to meet its burden of proving that the permit will be protective of the health and safety of requesters and their families, including sensitive subgroups. Under Title 30, Texas Administrative Code, Section 116.610A1, applicants for a standard permit, including a standard permit for a concrete batch plant, must meet the requirements of Section 106.261 and by reference Section 106.262, which contains certain emission limitations. Here, the evidence and testimony presented showed that Bosque's application did not demonstrate compliance with these sections. OPIC notes that the applicability of Sections 106.261 and 262 to the standard permit for concrete batch plants was a contested issue in this proceeding. However, OPIC finds that the record as a whole established that these sections do apply, and OPIC supports the ALJ's conclusion that Bosque must demonstrate that the application meets their emission limits. Further, it was shown at the hearing that these rule sections prohibit any emission of crystalline silica. It was undisputed that the plant's emissions would include sand, which Bosque and the executive director's witnesses agreed contains some amount of crystalline silica. Consequently, the evidence shows that the plant's emissions include crystalline silica. Therefore, OPIC agrees with the ALJ that because the plant would emit crystalline silica, the application fails to demonstrate compliance with these regulatory requirements, and specifically Section 106.261A3. Crystalline silica has known health effects, a carcinogen that can cause lung cancer and silicosis. However, because Bosque was under the impression that it did not need to comply with these sections' emissions limitations, its application did not calculate or consider crystalline silica emissions. Therefore, OPIC further agrees with the ALJ that Bosque has failed to establish that the application is protective of the health and safety of the requesters and their families. For these reasons, OPIC respectfully recommends Commission adoption of the proposal for decision and denial of Bosque's application for a registration under the standard permit for concrete batch plants. OPIC further recommends the Commission sustain and incorporate some of the proposed changes as set out in the Executive Director's Exceptions Letter. OPIC supports the ED's changes to proposed findings of fact numbers 29, 63, and the second portion of number 69, specifically the change of ESL to emissions limit 4. OPIC also supports changing the last sentence of page 17 of the proposal for decision from effective to effects, and changing the ordering provision to reflect that John Neerman is the Commission's chairman. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. Commissioner Lindley, any questions for Mr. Wayne? Commissioner Janeka, any questions?
No questions for me. Thanks for the input.
Hearing no questions, thank you again, Mr. Wayne. Let's return to the applicant. Mr. Larkin, you have reserved some time for rebuttal.
Chairman and Commissioners, I believe that our initial comments, and particularly the comments of the Executive Director, well support the issuance of this permit. I would take exception with assertions by counsel that no one has looked at the risk factors related to silica related to operation of a cement batch plant. The Executive Director has made very clear that in the development of the permit that silica-related risks were thoroughly evaluated and that the permit was designed to address those issues at the time of its initial creation, and that was the basis for having an exception. And I would certainly reiterate and emphasize that the typographical error in modifying what was published did not change what the law was, and that this agency relies upon the notice and comment procedure for creation and modifications of its rules, and the regulated community needs to be able to respect that. There was no opportunity, and I take exception from any assertion that there was a full public comment or hearing or any sort of input. I believe the record was that that modification occurred in the very latest stages prior to taking that modification to the agenda, and so there was not any such comment, notice or comment. And we need to respect the rule of law in that respect. So based on that, we believe that the very standard, very cut and dried cement batch plant permit can and will be complied with by our client, who is also a small businessman, who has a family man and has worked very hard to create the funds needed to establish this business, and has been in hard times through COVID, as everyone else has, and looks forward to operating this business in compliance and as part of its community and contributing to the community. So with that, we urge you to issue this permit. Thank you very much.
Thank you, Mr. Larkin. Colleagues, let me just be candid with you. This is a challenging item, and I've struggled finding a clear path through this. And so I'm gonna punt just for the moment and give you all an opportunity to lay out your thoughts on the issue, if you'd like to do that. I do have some observations to share that I'm trying to cobble together, but I wanted to give you an opportunity to weigh in first, if you'd like to do that. Commissioner Lindley?
I completely agree. This one, I found myself waking up in the middle of the night on Monday and thinking about it. It's very sticky and it's very muddy, and I've struggled with what to do. I think where I've landed, but I do want to hear y'all's thoughts, is probably with a remand back to SOA to dig into the issue of, to take more evidence regarding, I think, what's probably the main issue at hand here, which is the crystalline silica emissions. So I'll just stop there. I'll kind of end with that for now. I am very curious to hear y'all's thoughts, because this one was, I honestly don't, I'll just stop there. I'll stop there.
Thank you, Commissioner Lindley. And let me just interject. For me, this comes down to the silica issue as well. I think we've made our determination on the notice issue. If you all have a different view, let me know. But I think we've moved beyond that. There are some other issues that I think are more or less resolved and settled. The matter really turns on this silica issue in my mind. Commissioner Janeka, what are your thoughts?
I think that I'm in initial agreement with Commissioner Lindley in terms of her immediate concerns, and frankly, I think my outcome on this, I think that I'm not quite convinced that the record really supports permit denial, and it really goes to the point of the discussion, the level of detail in the record as to the amount of crystalline silica, where the proof positive that there was some amount in the mix was literally described as some amount, the word some amount in the record. I feel like that is a tenuous technical basis on which our agency can stand on insisting upon denial of a permit, and I'm also troubled in ruling with the ALJ's recommendations on this particular matter, how that may implicate or have ramifications for the broader agency program. So that's something that I really wanted to try to better inform myself about with ED, and I'm frankly just wanted to defer to you, Chairman, as to whether that was a topic to explore today, or if it's something that we need to just individually administratively rule on this issue, and then we can set that aside for another day. But I think that captures the bounds of my thinking and sensitivities on this one. I don't think I'm troubled with the prospect of remand in order to further develop the record, because I do feel like it's a little light to create a basis for denial, but I also don't know that I see a very clear exit route. I feel that there are some really unsatisfying elements to a remand as well. So I'll stop there and get your thoughts.
Yeah, thank you, Commissioner Janeka, and I share some of the same thoughts. Well, let me just begin with a few observations. So we have a standard permit for concrete batch plants that is protective of human health and the environment. It was developed for that purpose. We did look at all emissions coming from these operations, including silica emissions, when that authorization was created, and it's been amended over time. And it has, to be clear, it has authorized emissions, including emissions of silica, in a manner that is protective of its neighbors. And we're talking about an authorization that is currently used for several facilities in the state, not just this proposed facility. Standard permits generally pertain to all sorts of facilities. Sometimes use these emission limits that are set out in some detail in the permits by rule. And this is really just an incorporation by reference mechanism. Here in the permits by rule, we've laid out this table of emission limits, and so, for convenience, the standard permits sometimes refer to and incorporate those limits. Sometimes they don't, as was the case, some might argue, as is still the case with the standard permit for concrete batch plants. But as a general matter, the default position is that those permit by rule limits are incorporated unless otherwise specified. And that's the provision that we find at section 116.16a1. And what appears to have happened here is that this standard permit, because it was developed in a manner that's protective of human health and the environment, including all emissions, including silica emissions, the reference to the PBR limits were waived. It appears that waiver was that it was intended to be moved from one section to another in 2012, and by error it got removed from one section but not moved to the other. So now we have language that suggests that the PBR limits aren't waived, but they in fact do apply. So what we're doing is we're applying, the argument is, it's created this argument, and I credit protestants for discovering this and calling it out. That is good lawyering on their part. But what it's done is it's created an additional limit above and beyond, arguably above and beyond the limits set out in the standard permit for concrete batch plants. And it's my observation that in this case, those limits don't necessarily add anything to the determination of whether or not the authorization or the facility is being protective of public health and the environment. And that's particularly true if you read the PBR limits as setting forth a limit of 0 emissions for silica. And it leads to what is almost an absurd result, which is if you're going to authorize a concrete batch plant by a standard permit, you cannot emit, and you're going to reference the PBR, you cannot emit any silica. Well, sand is a pretty key component of concrete batch plants, so it creates almost an absurd situation if you take that argument to the logical extreme, that you can't authorize a concrete batch plant with a concrete batch plant standard permit. So that is quite a pickle to be in. And I'll confess, if you take just a plain reading, that is a reasonable reading of the rule. So let me pause there. listened to the arguments about whether this change in the standard permit was properly noticed or not. And candidly, colleagues, I'm not sure how those arguments would fare on judicial review. I'm not particularly enamored with them. There's another argument that I'm going to get to later. I'm not sure I'm enamored with it either. But all this is to say that I'm not sure what the correct path forward is on this application. I do think that it's incumbent on staff, if they haven't already done this, to undertake with great urgency a correction to this standard permit to resolve this issue and bring some clarity to the rule to avoid legal arguments that would have this absurd result that I just described. So, separate and apart from this action, I'm just encouraging staff to pursue that with all due haste. And I think what I'm ultimately going to suggest is I could really benefit from some more time to study and analyze this issue. So what I'm going to suggest is that we continue this item to allow us some time to do that, if that's agreeable with y'all. And you don't have to answer right now because I have some more thoughts to share. But before I do that, let me just pause and see if you have any reaction or reflection or comments on what I've said so far. Commissioner Lindley? And Commissioner Lindley, you froze up on me. Are you there? I can't hear you yet. You might double check your mic. I think we have some bandwidth issues.
Minute and try and switch to a different internet connection because.
Hey, you're back. I can hear you now. Go ahead.
Yeah, it did it while you were speaking a little as well. One thing I hate about this more than anything is, I already tossed out the idea of potentially supporting a remand to SOA. And I think I could probably get there on continuing it, but I'm very cognizant. One of the reasons why I'm a little uncomfortable continuing it at SOA, remanding it to SOA is just the length of time this thing has gone on. I mean, for the applicant, for the protestants, for ED staff, it kind of just drives me crazy that it's still going on. But I want to get it right at the same time. And this one is just the cards we've been dealt are very complicated. And I do think the issue. It sounds like the main issue we've all probably agreed upon, which still needs some to be dived into, is the emissions of the silica. That I think we need to explore that more. And so whether that's continuing it or remanding it to SOA, I could probably get there. I wouldn't want to continue it for long. I will say that, just because of the time that this has gone on and the cost. I'm very cognizant of how much this costs everyone, the protestants especially, and the applicant. I mean, paying for attorneys and all that stuff adds up. So I don't know. This one is, I haven't said much other than I could probably get okay with continuing it, but I wouldn't want to continue it for long. So I'll stop there.
Thank you, Commissioner Lindley. And what I might propose is continuing it to the May 19th agenda is what I had in mind. But Commissioner Janecka, any thoughts you want to share?
I very much appreciate your input on this one, Chairman, and I think that I'm particularly grateful to hear your thoughts on your opinion on some of the legal arguments that have been raised. And I think that I had the same initial thoughts about some of the arguments about whether proper notice was given in the revision to that standard permit previously. But I think that this issue really does. I don't think a continuance would be harmful at all in terms of giving us ample time to make sure that we've gathered the correct information. And Commissioner Lindley, I think that your desire to get this right is one that I very much share. And I think being thoughtful and deliberate in terms of making what is on this individual permit a proper call in regards to the broader context of our agency's posture on this program area, I think is really crucial. So I'm not averse to taking a little more time on that. Thank you, Chairman.
Yeah, thank you. Commissioner Lindley, did you have something to add? Okay.
No, I'm sorry. I was playing with my internet there for a minute. I think I'm back in business. If at some point you see me disappear, I'm re-signing back in, so I just pre-apologize for.
Okay. Well, you're coming in loud and clear now, so that's good. Yeah, so the purpose of the continuance is it may put us in a position where we can provide SOA better instructions on a remand is what I'm thinking. If we decide to go that path. But let me say this: whatever path we decide to go, it would be we'd be in a better position to articulate that, I think. I do want to share one other thought or legal argument. We talked about the notion that the protestants' argument that there is not currently a waiver of this incorporation by reference means that you have to comply with the emission limits of the permit by rule. And for the sake of argument, just in the hypothetical, let's say that you accept that, and you are required to incorporate by reference the limits in the PBR. The way the PBR sets out those limits, I think is worth a little bit of analysis. So at section 106, 261A3, they create a table, a list of emission limits for a set of constituents. So that's one class of constituents. And then at the last sentence of that section defines another class of constituents and carves those constituents outside the scope of the PBR. And that sentence reads, emissions of a chemical with a limit value of less than 200 milligrams per cubic meter are not allowed under this section. So one way of viewing that sentence, I think the view that the protestants would argue, the legal interpretation is that in itself is an emission limit, and by the way, that applies to silica, and therefore the emission limit for silica equals 0. That's one reading of it. I would propose an alternative reading, just for the sake of argument. You could read that as saying that that this class of constituents is outside the scope of the PBR. So if you're looking for the emission limits set out by the PBR, what you're really looking at is that table of emission limits. And those are the only emission limits. There is no emission limit for silica because that's outside the scope of the PBR, which is another legal argument different from what the protestants would urge, that could be a path forward here. And I offer that just in the spirit of brainstorming. I'm not going to, let me not share any other opinions or observations about that. But I want more time to think about that argument and all the others. But I wanted to tee that up for y'all so you can be thinking about that between now and the next time we meet on this subject. It may be meaningful in the end or not at all, but I just wanted to put that out there. I'm not sure that I have any other observations to share on this item at this point, but I do think it's not going to hurt to give us some more time to consider all these difficult issues.
So is your, I guess, thought to continue it to the next agenda, the 28th?
I was going to propose the May 19th agenda.
I'll be honest, I don't know if I want to go that long, just because of all the people involved. Here's why. The PDF was issued back in, I think, November. And so, at that point, it obviously takes time to get set on agenda. But these folks have been waiting for an answer, whatever it is, for already a number of months. So, anyway, on this topic.
Commissioner Ginecco, what do you think?
I'm very intrigued at the last remarks you had, Chairman. I'm interested, frankly, to try to educate myself on this topic a little bit better between now and when we next discuss it. And I think that I'm hearing from both of y'all some willingness for a continuance to either our next agenda or the second agenda from now. I think I'm in support of either of those directions. And the only thing that I really want to add, Chairman, thank you for those final remarks you've added. The only thing I'll add is that I strongly agree with you on making the point of encouraging executive director staff to work expeditiously to create or to eliminate any potential for confusion in this manner in the future on the standard permit. And if that's a clarification, another revision of that permit, or perhaps I think where you're going with this is that there may in fact be perhaps a different route entirely that we haven't yet fully considered today. So I'm very eager to better educate myself, better inform myself about the limits of the agency's ability to move forward at this point. But I sincerely appreciate the time to consider this more fully. Yeah.
Thank you, Commissioner Ginecco. Yeah, I would say that the way it stands right now, there's at least some ambiguity in the current standard permit for concrete batch plants that we need to clear up, separate and apart from the item that's before us this morning. Well, let's see. I mean, looking at my calendar and Commissioner Lindley, the reason I was picking up the second agenda out as opposed to the next agenda out is just just personal calendar, trying to find some time to give to it. But I also am very sensitive that this has been grinding on for quite a long time. Commissioner Ginecco, what are your thoughts on which agenda we might continue this to?
I think that my immediate thought was the demands of the legislative session and where our agency staff are already taxed and doubly or triply taxed in trying to be responsive both to our agency's routine schedule of business with agendas coming every 2 weeks or so, and then immediate demands on the agency staff time with legislators' offices' requests for relevant bills. I think I can go either way on continuance until April 28th or until May the 19th, and I think my preference is probably the latter of the two. The May 19th only for the same reason you gave, Mr. Chairman. It's a little hairy in the next 2 weeks for me already schedule-wise to be able to clear room if there's opportunities for further briefings or discussion on this. Not the permit matter specifically, but broader questions about, questions about alternative, just getting informed on what actions ED staff may believe is necessary with regard to the standard permit or trying to clarify for our regulated community.
Thank you, Commissioner Janeka. Commissioner Lindley, could you get comfortable or begrudgingly comfortable with a May 19th continuance? So,
Sure. I'll just leave it at that.
okay. Well, then, colleagues, I move that we continue this item to the May 19th agenda, and I'll ask for any additional thoughts or comments or a second to that motion.
I will just comment. I was trying to do a very big head nod. Both Chairman, when you were talking, and Commissioner Janeka, when you were speaking about giving directives to the ED, if they haven't already, maybe started working on a little bit of cleaning up the PBR language, because, like I said, this came out in November, so maybe it's already moving. I have no idea, but I would hope that, yes, it's being worked on. So anyway, that's my only comment.
Thank you, Commissioner Lindley. Commissioner Janeka, any more comments, or I'll invite a second?
I will only add that I second your motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the ALJ's proposal for decision and order regarding an enforcement action against Garrison Maurer. The ED should speak first, followed by the respondent, and then the Office of Public Interest Counsel. OGC recommends the standard 5 minutes for each oral presentation. The ED may save time for rebuttal as he bears the burden of proof.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is John Merkulieff, and I am representing the Executive Director in this matter. With me is Amanda Butcher with the San Antonio region. The Executive Director alleged respondent committed 2 violations related to unauthorized disposal of municipal solid waste and illegal outdoor burning at a site on which respondent operates a towing company. The Executive Director recommended respondent be assessed a penalty of $4,258. At the hearing, respondent stipulated that the Executive Director calculated the penalty properly. The only issue in dispute was whether respondent committed the alleged violations. Respondent argued that his actions fell within the exemption for disposing of municipal solid waste on one's own property and within the exception for burning municipal solid waste on one's own property over the authorization from the property owner. The Executive Director presented evidence and testimony that respondent does not qualify for the exemption or for the exception because he is not the owner of the property, but merely a beneficiary of the trust that owns the property. The Executive Director also presented evidence and testimony that the trustee did not give the authorization to respondent that he would have needed to qualify for the exception since he is not the property owner. The administrative law judge found that respondent violated TCEQ rules prohibiting unauthorized disposal of municipal solid waste and outdoor burning. The administrative law judge further found that the Executive Director correctly calculated the penalty regarding those violations and recommended the Executive Director's proposed corrective actions. The Executive Director concurs with the substance of the administrative law judge's proposal for decision and recommends adoption of the proposed order with the inclusion of the Executive Director's exceptions as recommended by the administrative law judge. These exceptions are intended to clarify the order. We're here to answer any questions you may have. I would like to reserve the remainder of my time for rebuttal if necessary. Thank you.
Thank you, Mr. Merkulieff. Your presentation made me realize that I was just a little bit sloppy in my analysis. I was thinking of the outdoor burning. I was thinking of the outdoor burning exemption and the municipal solid waste disposal exemption, both of them as exemptions. But as you pointed out, one is an exception and one is an exemption. Could you set me straight? Tell me which is which again. There's an exemption for outdoor burning and an exception to the municipal solid waste disposal requirement.
It's actually it's the other way. The municipal solid waste disposal has an exemption,
okay,
and the ban on outdoor burning has an exception.
Okay, got it. I'll try to get that straight now. I appreciate the clarification. That's my only question at the moment. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Thanks. Not at this time.
Thank you. We'll hear next from the respondent. I understand Attorney Chris Smith is with us.
That's correct, Chairman. Can you hear me?
Loud and clear. Good morning, Mr. Smith. Go ahead when you're ready.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka. My name is Chris Smith. I represent Garrison Mauer, the respondent. If you vote to adopt the PFD before you, it will make it a violation for landowners to clear and burn over 2,000 pounds of brush annually without obtaining an MSW permit. It will also require properties owned by legal entities to prepare formal letters to their agents, their employees, their beneficiaries, anytime routine outdoor burning takes place. These impacts will be felt not just by Mr. Mauer, but by landowners across Texas. In a nutshell, this case involves burning brush on a 1,200-acre ranch owned by a family trust. Garrison Mauer is one of 5 trust beneficiaries. The other 4 beneficiaries are also members of his family, and frankly, they're having a family feud. There's lots of civil litigation involving the trust itself. But each of the beneficiaries has an undivided right to use the entire ranch. Mr. Merkuliev is correct that staff have alleged 2 violations. One is an MSW violation, and the other is an outdoor burning violation. Both violations are unsupported by the evidence and are premised on faulty application of the regulations. Let me address the MSW violation first. The ED's position, which was adopted in the PFD, is this: even if a person burns on-site brush in accordance with the outdoor burning exception in section 111.209, if that person compiles more than 2,000 pounds of brush to burn in a year, it is still a Chapter 330 violation unless you have an MSW permit. This interpretation guts the outdoor burning exception. If you look at the outdoor burning exception, there's no weight limit. And 111.209 clearly contemplates that more than 2,000 pounds of brush may be burned because the text of that rule references trees, which are often over 2,000 pounds. Further, implicit in safe outdoor burning is an understanding that brush has to be piled to be burned, and depending on the weather, the pile may have to be left in place for some time until it can be safely burned. Mr. Mauer testified to this at the hearing. Staff's construction that you need a separate permit, even if you comply with the outdoor burning exception, is unreasonable. And for this reason, there's no MSW violation. Second, on the outdoor burning violation itself, section 111.209 authorizes outdoor burning, quote, by the owner of the property or any other person authorized by the owner, end quote. Uncontroverted testimony was presented that title to the ranch is held by a family trust, that Mr. Mauer is one of the 5 trust beneficiaries, that he has an undivided right to use and access the ranch, that he operates a business on the ranch, and that he's conducted clearing and burning on the ranch for years. This uncontroverted testimony establishes that he has authorization from the landowner. I ask, is it reasonable to require a beneficiary of a family-owned trust who has complete access to the ranch, including years of conduct clearing and burning brush, to obtain some type of formal letter every time it's necessary to conduct routine burning? It is not. And the application of some type of heightened evidentiary standard to this one element of the exception, while ignoring uncontroverted testimony that he's had a right as a beneficiary to conduct outdoor burning, was arbitrary. Aside from these 2 major issues, the record fails to support the remaining basis for the violation. Out of respect of time, I'm not going to get into those now, but they are brief in our exceptions to the PFD. Commissioners, I recognize that you may have a hesitancy to second-guess fact determinations of an administrative law judge, and I'm totally respectful of that. But the unreasonableness of staff's position regarding the application of these 2 regulations, that you still need an MSW permit to conduct outdoor burning over 2,000 pounds, and that the beneficiary of a family trust who has complete right to use the ranch does not have authorization to burn, is emblematic of the approach to this whole case, which is an overzealous prosecution of regular ranch activities that are done every day across the state. The last thing I'd note is that staff rely on PFDs as precedent. If you vote to adopt this PFD, you will be endorsing staff's position that a person cannot burn over 2,000 pounds of brush without a separate MSW authorization. I urge you not to do that. Thank you for your time, and I'm happy to answer any questions you may have.
Thank you, Mr. Smith. I don't have any questions at the moment. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka?
No questions at this time.
Thank you. Let's hear next from Public Interest Counsel.
Good morning again, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and Staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. OPIC agrees with the Administrative Law Judge and the Executive Director that respondent committed the violations as alleged in the Executive Director's first amended report and petition. Further, OPIC notes that the parties stipulated that the proposed penalty as recommended by the Executive Director was calculated consistent with the Commission's penalty policy. Therefore, OPIC agrees that the penalty recommended by the Executive Director is reasonable and correctly calculated in accordance with applicable statutes, agency rules, past agency practice, and the TCEQ penalty policy. Finally, OPIC finds that the corrective actions recommended by the Executive Director are both necessary and appropriate. Consequently, OPIC respectfully recommends that the Commission adopt the ALJ's proposal for decision, sustain and incorporate the changes contained in the Executive Director's exceptions numbers 1 and 3 through 7 to the proposal for decision, and make the minor corrections to the proposed order as recommended by the Executive Director in exceptions numbers 8 through 10. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thanks.
Thank you. Mr. Mercourial, you've got some time reserved for rebuttal, I think, if any.
Thank you, sir. Yes, I would like to address a couple of points. As far as the beneficiary status of Mr. Maurer, respondent, it is true that he is a beneficiary of that family trust, but beneficiaries enjoy use of the property, but are not the owner of the property under these circumstances in this case. So that really kind of, that takes his needs out as far as trying to qualify for the exemption regarding the disposal of municipal solid waste and qualify for the exception regarding the outdoor burning ban. And we did have testimony that, in fact, the trustee we got permission from the trustee to reveal her identity as the complainant on the initial investigation. So we have shown that the owner of the property did not give authorization for that outdoor burning. And as far as I heard reference a moment ago to, well, they're going to have a permit, an MSW permit, municipal solid waste permit. And that's not the only avenue. And I did hear another phrase in their authorization. What that exemption is from is it's an exemption from a permit, a registration, a notification, or other authorization. So there are multiple avenues that responsible property owners have to pursue to get permission to perform the outdoor burning that they need to perform on their land, as far as the clearing of the land, and of course, they typically burn it from there. So this is not the catastrophic result that is being suggested. That we have ways in the rules for responsible property owners to conduct the activities that they need to conduct on their ranches or whatever large properties that are out there. So I believe that's the extent of my rebuttal. Thank you.
Thank you, Mr. Mercourial. I appreciate that. Colleagues, the concern about reading the outdoor banning and MSW disposal authorities together such that it creates an impossibility for ranch owners, I'm a little doubtful of those arguments to begin with, and appreciate Mr. Mercourial's explanation that there are a number of avenues for ranch owners who want to clear their lands to do that under different forms of authorization that the agency has. I don't think we even get to that issue, because for me, this all turns on the question of ownership. And I do feel, I appreciate Mr. Smith pointing this out. We have been pulled into a family feud here. So let me just lay out my reading of the matter. Here our respondent asserts that his rights to the trust property are sufficient to support the outdoor burning exception and the MSW disposal exemption. But although he has certain rights to the property as a beneficiary of the trust, the ALJ decided that they don't amount to ownership sufficient to establish the exemption and the exception. And the ALJ makes additional findings that would independently render the exemption and exception inapplicable. And I happen to think that the ALJ is correct in her legal analysis, and I really have no basis to second guess her reading of the evidence. So I would follow the advice of Public Interest Counsel and the Executive Director and adopt the proposed order with the corrections that the ALJ noted in her letter of March 30th. So that's my reading of this item. Commissioner Lindley, what do you think?
I'm in agreement with you, Chairman.
Easy enough. Commissioner Janeka?
Likewise, and I appreciate you raising that point, Chairman. I think that Mr. Smith's questions about reasonableness are well taken. That's a point very well taken in terms of it doesn't strike me as entirely reasonable to insist that our agency expects and requires a formal letter, a formal document every time outdoor burning is going to occur. But I would set that hypothetical aside and say this is a different circumstance. And I think I'm in agreement with you, Chairman, that the ALJ properly concluded that there's a little better evidence that, in fact, the owner in the proper legal sense, the individual with a far closer claim to being the owner of this trust-owned property really did clearly indicate there was not approval when they were involved in making the complaint that brought this about. So I'm in full agreement and happy to move forward. I could propose a motion when we're ready to that.
I think we're ready. Go ahead.
Then I'll go ahead and move that we adopt the administrative law judge's proposed order as amended by her March 30th, 2021 letter.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item. Ms. Smith?
Item number, sorry, I had trouble unmuting myself. Item number 3 is the application by Equistar Chemicals LP for air quality permits number 4682B, PSDTX 761M4, and GHG PSDTX 32M1. The parties have been notified that the Commission will not take oral argument, but may ask questions. Anyone who has signed in will be noted for the record.
Thank you, Ms. Smith. And colleagues, we have, of course, a two-part analysis for considering requests for contested cases. First, the threshold issue. We consider whether requesters have met the procedural and substantive requirements to be entitled to a contested case. Assuming we have one requester who meets those requirements, we then consider which issues are appropriate for referral. So part 1, the threshold issue, is who gets a hearing. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And in this case, we have 3 requesters. 2 of them reside more than 16 miles from the facility, so their interests are not distinguishable from the general public. The third requester, Ms. Miller, is located about 1 3/4 miles from the facility, which is also a considerable distance. And in addition, Ms. Miller does not identify a personal concern. So I agree with the Executive Director and Public Interest Counsel that we should deny the request in this case. And colleagues, let me gather your thoughts. Commissioner Lindley?
I'm in agreement. I would be comfortable with denying the hearing request today and adopting the RTC.
Commissioner Janeka?
I'm likewise in full agreement with the 2 of you.
I can make a motion. Sounds like we're ready.
Go ahead.
I would move that we deny the hearing request, that we issue air quality permit numbers 4682B, PSD TX 761M4, and PHG PSD TX 32M1 to EchoStar Chemicals LP as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second that motion.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application for the creation of Prairie Oaks Municipal Utility District of Denton County. The parties have been notified that the commission will take will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. And colleagues, on this item, we have one request for a contested case hearing, and that's from State Representative Jared Patterson. And in looking at his request, I don't see that the representative has demonstrated a personal justiciable interest. He does not allege a residence or property ownership in or near the proposed MUD, or allege personal concerns about the MUD. His concerns are really about potential impacts to the city of Oak Point and not to himself. So I have to agree with the Executive Director, the Public Interest Council, and the petitioner that we should deny that hearing request. I think it's fairly clear, but let me ask you, did you come out in the same place, Commissioner Lindley?
I did.
Commissioner Janeka?
I did as well, although I had one point that I was hoping to try to clarify on the record for this item, if I might be granted a little leniency to ask one of the witnesses I think we have available for the developer question.
Go ahead.
And thank you. I will. I note that we had a couple individuals registered for the applicant in this matter, Mr. Paul McCracken and Mr. John Dodal. I don't know which of you would be best qualified to speak to this, but the question that I really wanted to ask is, if we decide to grant the petition to create this MUD, the Water Code requires us to appoint 5 temporary directors to serve until permanent directors are elected. And the Water Code, the relevant section of that Water Code says that the temporary directors must live in the same county and adjacent county or in the same metropolitan statistical area. And I just wanted to ask the applicant if they could confirm for me that each of the 5 temporary directors recommended by the petition do live in Denton County, a county adjacent to Denton County, or the Dallas-Fort Worth metropolitan statistical area.
And I'll invite whoever wants to represent the petitioner in answering this question just simply to identify yourself for the record and then go ahead.
This is Scott Eidman for the petitioner, and we do meet that requirement. We have 5 temporary directors that are listed in the application. They do live in that area, so they do meet that requirement.
Okay. I appreciate that, Mr. Eidman, and I think that was one excessively nitpicky point that I wanted to try to drill down onto, but otherwise have no objections. Thank you, Chairman. I'm ready to move forward today if you are.
Thank you, Commissioner Janeka. Well, I think we've disposed of the request for the contested case hearing. Let me make a few comments on the merits of the petition. Our job is to determine whether the project is feasible and practicable and is necessary and would be a benefit to the land to be included in the district, which is quite a mouthful, even for statutory language. But that determination includes the Commission considering whether comparable services are available from another system, considering the reasonableness of the projected construction costs, and then the tax and utility rates. It requires us to consider factors relating to whether the district and the development would benefit the land relating to groundwater, water quality, subsidence, and so on. And in my view, the petitioner makes the required demonstrations. I also, in my reading of it, believe that the requirement for city consent under the Texas Local Government Code has been satisfied. And I do believe, and I appreciate the clarifying question, Commissioner Janeka, I do believe, especially with that testimony from Mr. Eidman, that the petitioner has proposed qualified directors. So I believe I'm prepared to grant the petition and wanted to gather up any additional thoughts from the two of you. Commissioner Lindley?
Commissioner Janek, I'm glad you asked that question. I had a similar question to mine. I kind of have a follow-up question to that. And I will just state, I'll just be very candid and say, I don't feel like I should have to ask this question. I feel like the applicant should have clarified this in their application, and in the ED's review of the application, it should have been clarified. But for me, it wasn't clear, so I'm just gonna ask it now so that it can be clear in the record. So in the affidavit statements about the temporary directors, the proposed temporary directors, it stated that they own property within the proposed district and that they are not developers of the property or related to developers of the property, which is a requirement. However, the Denton County tax appraiser certified that its tax rolls, wait, did I say that right? Let me restate that, I'm not sure I said it right. In the affidavit, it says that each of the temporary directors state that they own property within the proposed district, but that they are not the developers or, again, related to the developers. But the Denton County tax appraiser certified that its tax rolls show that the 2018 Blackhawk 31 Holdings Limited holds title to 100% of the value of the property in the proposed district. So there's kind of a discrepancy there, when you're saying these folks own property, but the tax records say a different entity owns 100% of the property. So just seeking to get a little bit of clarification there.
So this is Scott Eidman. The directors are conveyed, an interest in property within the district, and we're happy to provide that documentation to show that they've been conveyed property that's within the boundaries. That's usually how that's handled.
Yeah, I would have hoped that would have been in the application already. I'll just say that. But with that, I am comfortable denying the hearing request and moving forward with granting.
And Commissioner Lindley, let me just add a little bit more in answer to your question. Yeah, I think that in the industry, and I'm not sure that our agency has done any favors in helping to clarify this, but I think in the industry, there's sort of some blurring of the lines between the qualifications for temporary directors and permanent directors, and I think that they're, probably using some kind of form affidavit for permanent directors, which isn't quite appropriate for temporary directors. And I'll share with you that I'm already working on having a sidebar with staff to try to clear that up, just so everything is by the numbers when it reaches us. And I think that we have provisions in our rules for permanent directors, but not temporary directors, which sort of could compound the confusion. But hopefully we can, we can help, our agency can help industry get the correct forms in place and avoid this kind of issue in the future. That's the way I looked at it. I had flagged the same issue, but I think we're good on this one. We just have some cleanup work to do to clarify things going forward.
I agree, and I completely agree, and I'm glad you've already had conversations. And one of the main reasons why I asked the question was to get it cleaned up for the record, so that way it, we can feel comfortable granting it. And I can make a motion unless you.
Why don't you go ahead and do that, and then we'll invite any additional comments from Commissioner Janeka.
Okay. Well, I would move that we deny the hearing request of State Representative Jared Patterson, that we grant the petition for creation of Prairie Oaks Municipal Utility District of Denton County, and appoint the 5 temporary directors proposed by the applicant and recommended by the ED.
I second that motion, and I don't have any further discussion or questions to add. I appreciate the input from both of y'all, and I think I'm in agreement across the board.
Thank you, colleagues. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Actually, before we vote, can we take a little break? I just have one other question that came up in my mind, but I'd rather talk to General Counsel real quick. So,
sure. You want to?
I have 10:55, maybe at 11 we come back together.
Okay. So it's 10:54 right now. Let's take a short recess and reconvene at 11.
Okay, thanks.
Okay, with that, we stand in recess. All right, colleagues, the time is 11 o'clock. We're back after a short recess. And Commissioner Lindley, were you able to get your question answered?
I'm comfortable with the motion I made, and I'm comfortable moving forward with taking a vote. So thank you.
Okay. And just to make it easier for anybody who might be going back reviewing our archives on this, I'm going to ask if you'll indulge me to make the motion again so we can have it all in one clip.
Of course. I would move that we deny the hearing request of State Representative Jared Patterson, that we grant the petition for the creation of Prairie Oaks Municipal Utility District of Denton County, and appoint the 5 temporary directors proposed by the applicant and recommended by the executive director.
I second the motion.
Thank you for that, Commissioner Lindley. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is the application requesting approval for the creation of Rancho del Cielo Municipal Utility District of Williamson County. The parties have been notified that the commission will not take oral argument but may ask questions. We do have parties signed in and they will be noted for the record. I understand that the hearing requesters filed a withdrawal letter this morning and that the ED would like to make a motion for remand. So I do recommend that the commission recognize the ED staff on this item.
Thank you, Ms. Smith. Let's hear from the Executive Director staff at this time.
Good morning. This is Kayla Murray in the Environmental Law Division representing the Executive Director. Since the hearing request has been withdrawn by the requesters, the ED requests that this matter be remanded back to the ED for processing. Thank you.
Thank you, Ms. Murray. Colleagues, with that, I move that we remand the petition for the creation of Rancho del Cielo Municipal Utility District of Williamson County to the Executive Director. Is there a second?
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 6 is the application by Steel Dynamics Southwest LLC for authorization to construct a new wastewater treatment facility. On March 23rd, 2021, the parties were notified that there would be an opportunity for presentations limited to 5 minutes for each party. Applicant Steel Dynamics Southwest should speak first, followed by the Executive Director, the Office of Public Interest Counsel, and then anyone who is registered to speak. And I believe at this time no one is currently signed in. The applicant may reserve time for rebuttal.
Thank you, Ms. Smith. And I understand we have Mr. McCarthy here for the applicant. Are you there, sir?
Yes, Mr. Chairman, Ed McCarthy here. Can you hear me?
I can, loud and clear. Go ahead.
Thank you, Mr. Chairman, Commissioners. My name is Ed McCarthy. I'm here today with David Hatchett, Environmental Counsel for Steel Dynamics, as well as the Sinton Plant Engineering Manager, Mr. Tom Wilcox. They're available to answer any questions you may have that are beyond my institutional knowledge of the project. Steel Dynamics is here this morning to request the Commission's approval of our request for authorization to construct wastewater treatment facilities at the Sinton Steel Mill while we're awaiting a final decision on our pending TPDES permit application. I'd like to start this morning by giving you a quote from Mr. Jim Blackburn, president of the Aransas Project, often known as TAP. Mr. Blackburn said, "There is a lot of work to be done going forward. We are rolling up our sleeves and beginning the process." I'm going to explain to you in just a minute where that quote comes from and why it's so important. It's important because we want to highlight for the Commission 2 things. One, Steel Dynamics' desire to obtain the requested authorization for construction in advance of the issuance of the TPDES permit in order to facilitate the company's efficient and orderly advancement of its investment in a $1.9 billion steel plant in South Texas. This plant's going to make a significant contribution to the economy of both the region and the state of Texas. I also want to highlight Steel Dynamics' responsiveness to the Commissioner's advice that you provided to the company in February of this year. After the February 24th agenda meeting, Steel Dynamics engaged with TAP and began to listen to and address the concerns and issues TAP had with the project and work towards a resolution of those concerns. As you know, TAP is a nonprofit organization which represents a number of interested parties along the Texas Gulf Coast, including downstream of the proposed discharge by Steel Dynamics. In those discussions, Steel Dynamics listened to the concerns and worked cooperatively with Mr. Blackburn and the leadership of TAP to craft a resolution that addresses those in a manner that includes a significant enhancement to the high degree of treatment Steel Dynamics already plans for the discharge from the effluent of its plant in Sinton. On March 24th, Steel Dynamics joined with TAP to announce that they had reached agreements regarding the pending permit application. Those agreements include Steel Dynamics' commitment and agreement to construct a wetland that will provide further treatment and polishing to its already high quality effluent before its discharge. And on TAP's behalf, TAP agreed to withdraw its comments and request for a contested case hearing on Steel Dynamics' pending TPDES permit application and this request for the authorization to construct. Those documents have been filed with the Commission. We have also filed with the Commission copies of the press release that was issued jointly by the parties. And the quote that I gave you comes from that press release by Mr. Blackburn. Steel Dynamics currently employs thousands of South Texas construction workers at its 2,500-acre plant. In addition, it currently includes 400 crafted tradesmen that are working on different aspects of the permit. With the authorization to construct, we will be able to grow that to an additional, ultimately additional 700 highly paid permanent employees at the Sinton plant. Steel Dynamics is investing as much as $3 million per day on completing its plant. Once operational, the steel plant will generate tens of millions of dollars in revenue on a weekly basis. Construction of the wastewater treatment plant facilities will take 60 to 90 days. By getting authorization to construct now, we're able to complete that, not doing any discharges or using the plant, but using it for other operations at the plant which do not require a discharge permit. That will allow us to continue the operation and avoid what would be the harm in denying this authorization. That includes the loss of the jobs I've just described, a delay in the operational status, and as much as hundreds of millions of dollars of revenue into the Texas economy. Granting the authorization will not authorize any discharges, will not change the requirements for us to satisfy the requirements to obtain a TPDES permit, but will allow us to move forward orderly and efficiently at this time. And we request your granting. And as I said, my time is up, but Mr. Hatchett and Mr. Wilcox are here to answer any questions.
Thank you, Mr. McCarthy. I appreciate the presentation. I don't have any questions for you at this point. Commissioner Lindley, any questions?
I don't have any questions. I will just make the comment that, in my opinion, that was a very good presentation. And the one or two questions I might have asked, you addressed. And so I really appreciate you laying things out the way you did. And, you know, I'll just say I thought the responses and the backup file for the agenda didn't quite get at some of the, at least one of the questions that I had asked wasn't addressed, but your presentation just addressed it. So I'll just go ahead and state, I guess, because I had strong opinions last time, so I'll just state them now, that I'm going to be comfortable granting the application, and just stress the point again, and I know you all know this because you checked the boxes and agreed that you understand this, that the permit could always change, and y'all are agreeing to go forward with construction. And if things change and there are costs that accrue because of changes in the permit, y'all recognize that that's just part of it, and you agree to understand that. So those are my only comments. I'm good. Thank you.
Thank
Thank
you,
you.
Commissioner Lindley. Commissioner Janeka, any questions for Mr. McCarthy?
No questions. I thank you very much for your presentation, Mr. McCarthy. I think that it reflects significant efforts from you and your company, and I sincerely appreciate y'all, in my opinion, heeding the words, the encouragement from our commission and from the chairman specifically when y'all were before us previously. So thank you.
Thank you, Commissioner.
Thank you, Commissioner Janeka. We're going to hear next from the Executive Director.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka, General Counsel, and Public Interest Counsel. My name is Hollis Finley, and I'm an attorney with the Environmental Law Division representing the Executive Director. According to its application, Steel Dynamics has requested an authorization to construct before the issuance of a Texas permit to allow for reasonable and efficient construction startup and operation of its planned $1.9 billion steel facility according to schedules for many of the skilled trades involved in its overall site construction. Steel Dynamics asserts that an authorization to construct is necessary to prevent delay, which would require multiple contractor mobilization to the site and lead to disjointed work that may affect the integrity and cohesiveness of the finished foundations, piping, electrical runs, and related work. Further, Steel Dynamics asserts that even if the Texas permit is not issued, the wastewater treatment system would serve other useful functions at the steelmaking facility, including water storage, preparing water for use as reclaimed water or for evaporation, serving as a treatment and volume reduction step before off-site disposal or other similar purpose. Steel Dynamics states that there are currently thousands of construction workers performing work on the facility according to a carefully planned 3-month timeline. Texas Water Code 22.027C states that a person may not commence construction of a treatment facility until the commission has issued a permit to authorize the discharge of waste from the facility, except with the approval of the commission. The commission's authority to approve or deny a request for an authorization to construct is discretionary under the statute. The approval of an authorization to construct would not bind the commission in its final permit decision, and if the authorization to construct application were granted, Steel Dynamics would be constructing the wastewater treatment facility at its own risk. After reviewing the ATC application, the Executive Director finds that Steel Dynamics has provided a valid basis for obtaining authorization to construct the wastewater treatment facility by explaining the necessity to allow for orderly and efficient construction and operation of the proposed wastewater treatment facility in conjunction with non-wastewater treatment aspects vital to the steelmaking process. I am available for any questions you may have. Thank you.
Thank you, Mr. Henley. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None. Thanks.
Let's hear from Public Interest Counsel.
Good morning, all. I'm Sheldon Wayne, Assistant Public Interest Counsel. Steel Dynamics previously submitted a request for authorization to construct this same facility, which was denied by Commission Order on March 3rd, 2021. Steel Dynamics states that it has submitted this second request because it felt that its first application was incomplete and to address concerns the commissioners articulated while considering the first ATC. OPIC appreciates Steel Dynamics' efforts to provide a more thorough application. Steel Dynamics states that the treatment facility will serve other functions if no TPDES permit is issued, that the startup of the entire steel mill depends on the construction of the treatment facility, and that the facility is necessary for all wastewater handling scenarios envisioned, regardless of whether a TPDES permit is authorized. Applicant represents that in the event a TPDES permit is not issued, the treatment facility can and will serve other functions, such as water storage, reclamation, and/or evaporation purposes, and pretreatment and volume reduction. The application makes clear that Steel Dynamics has needs for a treatment facility that are not contingent on obtaining a TPDES discharge permit, and the applicant has acknowledged that there are wastewater disposal alternatives in the event that a permit is not issued. The representations in this second ATC application also indicate a stronger acknowledgement by Steel Dynamics that the granting of this authorization to construct would carry no evidentiary weight whatsoever in any future SOA or commission proceedings on the underlying TPDES permitting proceeding. Based on the additional representations Steel Dynamics has now provided, OPIC does not oppose applicants' requested authorization to construct. OPIC believes that these additional assurances that the treatment plant would be used by the applicant even if no wastewater discharge is permitted, acknowledge other reuse or disposal methods, and should help address concerns that the public may perceive the TPDES permit to be a done deal. As to the other reasons presented by the applicant or the ED for granting the ATC, OPIC was not persuaded. Regarding the settlement with the Aransas project and the proposed 50-acre wetland project, OPIC applauds this development, but it has not affected our position. The TPDS application is still the object of significant opposition, with numerous public comments, hearing requests, and public meeting requests received by the Commission. Regarding arguments about harmful delay and how the permitting process might be extended if any hearing request is granted, OPIC notes that if an expedited timeline was so essentially mission critical for Steel Dynamics, the TPDS permit application could have been directly referred to SOA at the time the executive director's preliminary decision was issued in October of last year. Had that happened, under Senate Bill 709's 180-day hearing limitation, conceivably the hearing could have already concluded, and we could be awaiting the ALJ's proposal for decision on that permit right now. The situation Steel Dynamics has presented to the Commission is less than ideal. It requires a balancing of equities and interests, and ultimately requires the Commissioners to make a tough call. OPIC cannot go as far as to support Steel Dynamics' request. However, based on the additional representations acknowledging other needs and uses for the wastewater treatment facility, OPIC is not opposed to Steel Dynamics' application for an order authorizing commencement of construction. If the Commission is inclined to grant this authorization, OPIC respectfully suggests modifying language contained in ordering provision number 3 of the Commission's proposed order. In its current form, this provision could be read to imply that Steel Dynamics will obtain a TPDS permit from the Commission. Therefore, OPIC respectfully submits that the word until should be removed and the word unless inserted in its place. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Commissioner Lindley, any questions?
No questions. Thank you very much.
Commissioner Janeka?
No, I just want to thank Mr. Wayne for making I think a very clear and well articulated argument for the public's interest in this matter. I appreciate your laying out some of the complexities before us on it.
Thank you, Commissioners.
Mm-hmm.
Thank you, Mr. Wayne. Ms. Smith, has anyone signed in to speak on this item?
No one else is registered.
All right, thank you. The applicant has used all of its time, colleagues, of course, we're free to ask any additional questions of anyone, including the applicant, if we want to do that, and chime in if you want to. But let me begin with a few of my thoughts on this item, and let me begin by thanking Mr. McCarthy and Mr. Blackburn and Mr. French for getting together on this and working through your differences and for arriving at a solution to address water quality concerns. I applaud that. And colleagues, even though that agreement is more of an issue for a later date when we address the merits of the draft permit, it is significant to me that TAP is not here today objecting to this request to construct as they were a few weeks ago. I do think that our general policy of disfavoring requests to construct before a permit is issued is an appropriate approach. It's an appropriate policy. And in this matter, I agree with OPIC that this is not a perfect application. It is a much improved application, but it's not perfect. The merits do cut both ways. But on balance, given the developments since we considered the first request, I do support granting this application. And let me pause there. I think, Commissioner Lindley, we heard your views. Let me invite you to add any additional thoughts or comments if you have them, and then we'll hear from Commissioner Janeka.
I really don't. Thank you.
Thank you. Commissioner Janeka?
I have no objections moving forward today as well. I appreciate it. And I was merely wanted to try to focus on a little bit more on the one point raised by OPIC. I think that's a very subtle but perhaps very important point, and I just pulled that up, the ordering provision that Mr. Wayne referenced, requiring or prohibiting Steel Dynamics against operating or discharging effluent from a facility under the order until it obtains a permit from the Commission. I think his point is a good one, that unless it obtains a permit from the Commission does convey a slightly different meaning. So I think I'd like to try to get clarification whether that revision may be in order to instruct on this one, and I don't agree that way anymore. So let me, I think on further clarification, I am comfortable moving forward as ED initially prepared. So let me just circle back and conclude and say thank you so much for that suggestion. I appreciate it, and I agree with the sentiment of it, but I think that the current language before us is appropriate to move forward. So let me backpedal on what I just suggested there, Chairman. Thank you.
Yeah, thank you, Commissioner Janka. Yeah, the word until in ordering provision number 3, let's just be totally clear. That's no promise that a permit will be issued or prejudicial. It really has no bearing. The application and the draft permit will stand or fall on its own merits, and our action today doesn't have any bearing on that. But I appreciate the sentiment behind the comment. I don't think I have anything else, so I think I'm ready to entertain a motion if y'all are ready.
Let me pile in there. I would like to move that we grant the application of Steel Dynamics Southwest LLC for an authorization to construct and issue the executive director's proposed order.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 7 is the consideration of the request by DR Horton Texas Ltd. to withdraw its application for TPDES permit number WQ 00156860001 to treat and discharge domestic wastewater from the Cypress Cove Wastewater Treatment Facility. The ED should speak first, as he filed the motion to remand, followed by the applicant, protestants, and then OPIC in that order. OGC recommends that each party be allowed 3 minutes to make their respective presentations. As always, the Commission may grant additional time as needed.
Thank you, Ms. Smith. And Mr. Henley, I understand that you're here for the Executive Director again?
Correct.
Well, good morning again.
Yes, good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka, General Counsel, and Public Interest Counsel. My name is Hollis Henley, and I'm an attorney with the Environmental Law Division representing the Executive Director. DR Horton Texas Limited applied for a new Texas permit to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 400,000 gallons a day. The Commission referred this application to the State Office of Administrative Hearings for a contested case hearing by interim order issued February 5th, 2020. At the applicant's request, SOA postponed the preliminary hearing to allow for lengthy settlement discussions. The judge's order stipulated that the preliminary hearing would not be scheduled until the applicant indicated to the court that it was prepared to proceed with the hearing. On February 11th, 2021, applicant DR Horton requested to withdraw its permit application. Since the SOA preliminary hearing has not yet been scheduled, SOA has not taken jurisdiction on this matter. Therefore, the matter of DR Horton's permit application is still under the jurisdiction of the Commission. As no facts or issues remain controverted in this matter, the Executive Director respectfully recommends the Commission grant the applicant's request to withdraw the application. I am available for any questions you may have. Thank you.
Thank you, Mr. Henley. I have no questions. Colleagues, any questions?
No questions.
None, thanks.
All right, let's hear next. I understand Ms. Scott is here representing the applicant.
Yes, this is Natalie Scott with Coates Rose Law Firm representing DR Horton, and I'm really just available for questions that we have entered into an agreement with the City of Garland to provide the wastewater services, which is the reason that we've requested to withdraw the application.
Great. Thank you very much, Ms. Scott, for being here and being available. I have no questions. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No questions for me. Appreciate it.
All right. Thank you all.
Thank you, Ms. Scott. And I understand, Ms. Smith, that we don't have anyone signed in to speak, no protestants on this item.
That's correct.
Thank you, and we'll hear next from Public Interest Counsel.
Good morning. OPIC has no objection to the dismissal of the application based on the applicant's withdrawal.
Thank you, Mr. McWhorter. Colleagues, this is real simple. I think we should remand this item so that it can be withdrawn. And I'm ready to entertain any additional thoughts or a motion.
I'm in agreement, and I can make a motion. I move that we remand the application by D.R. Horton, Texas Limited for new TIFDES permit number WQ001-5686001 to the Executive Director to process the withdrawal of the application.
I second the motion.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 8 is the consideration of the nomination and appointment of one person to the Tax Relief for Pollution Control Property Advisory Committee. The Executive Director's staff is here to present this item.
Thank you, Ms. Smith. Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Elizabeth Sartain with the Air Quality Division. With me is Don Redman with the Environmental Law Division. As described in Section 1131 of the Texas Tax Code, the TCQ shall establish a permanent advisory committee to advise the Commission regarding the implementation of the Tax Relief for Pollution Control Property Program. An appraisal district representative position is available because one of the members whose term expires on December 31st, 2021, resigned his position effective December 31st, 2020. Notice of the vacancy was posted in the Texas Register and on the TCQ website to solicit applications. The submitted applications and the Executive Director's recommendation for appointment to the vacant position are presented today for your consideration. We thank you for your consideration of this matter and are available to answer any questions.
Thank you, Ms. Sartain. I have none. Commissioner Lindley, any questions?
No questions. Thank you for your work on this.
Commissioner Ginecka?
No questions. Thank you for presenting, I think, a qualified candidate for consideration.
Thank you, Commissioner Ginecka. Ms. Smith, has anyone signed in to speak on this item?
No one is signed in.
Thank you. And what are the thoughts of the Public Interest Council?
OPIC recommends approval of the resolution appointing Mr. Landrum to the Tax Relief for Pollution Control Property Advisory Committee as presented by the Executive Director.
Thank you, Mr. McWhorter. I agree with that, colleagues. This is an important committee. I do want to thank its members for their service, and I want to thank our nominees for their willingness to serve. All of them are highly qualified, but of course, we just have one position to fill, and I don't see any basis to depart from the staff's recommendation on this. So I'm ready to move forward, and I will entertain any additional thoughts or a motion to that effect.
I will move that we adopt the proposed resolution appointing Hugh L. Landrum, Jr., P.E., to the Tax Relief for Pollution Control Property Advisory Committee as a representative of an appraisal district to complete the remaining term of Darrell D. Attaway, set to expire on December 31, 2021.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
That takes us to our enforcement docket, items 9 through 20. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordella of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 20. The total assessed administrative penalties are $324,579, with $49,271 deferred, $50,625 applied toward supplemental environmental projects, and $224,683 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Ginecka?
Likewise. No, thank you.
Thank you. We're going to turn next to interested persons. I understand that Mayor Moffitt with the City of Mingus may be with us and wishes to speak. Mr. Moffitt, if you're there, good morning.
Good morning. You want me to talk now?
Yeah, go ahead, sir. We're getting you loud and clear, and the floor, the floor is yours.
Okay, I'm going to explain to you our situation. Okay, Mingus, it's a small town, and there's like 240 people live here. We do not have a water treatment facility. We buy treated water from the city of Strawn. So when we got these high levels, we called Strawn, and they were also getting them. So we called it's William Powell, and he works for Jacob and Martin, and he's got an A water license. So Bill went to their water plant, and he made some suggestions on things that they could change. And we also, talking with Jacobs and Martin, and the main engineer on that job was Derek Turner, but we talked about adding a chlorine injection in Mingus on the inlet of our water tower. We applied for that. We've recently done some, put in some new lines through a TDA grant, and we were also going to include the the chlorine injection, but the state disapproved it. But they have since approved it, and we actually open bids next week on Friday. So that's the only thing we could do. Our only option now is just when we get a high reading is, we just have to flush the water. So, I guess that's it in a nutshell. I don't know anything else to say about it.
Well, thank you, Mr. Moffitt. Appreciate the explanation of what's going on out there. Are there any concerns that you have with the agreed order that y'all signed on to, or does that accurately reflect kind of where you are with this item?
Okay, by the agreed order, I'm not sure what you're talking about. Originally, we've got a new city secretary, but the other secretary explained this to somebody, and they agreed to not make us pay the fine if we could come up with some way to correct it. So our correction was to add this chlorine injection system, which so if that's what you're talking about, yeah, I'm okay with it. We've done our part. We're just we're waiting to get the bids now because it was finally approved, and then we would install it as soon as we could. We just finished putting in some new lines, and we were going to try to do it at the same time, but it just didn't get approved yet. So
sure.
So yeah, I guess I'm okay with it if that's what you're talking about.
Yeah, that's it. And what it is that when those trihalomethanes were out of compliance, we noted that and we cited that as a violation. But then, as you pointed out, we assessed a penalty, but then we deferred that penalty because of the steps that y'all took that you just described to correct it. So the agreed order just documents all that and says that the penalty is deferred. You don't owe it, and so that's what's on our agenda, the commission's agenda today. But I really appreciate you calling in and letting us know and hear kind of the challenges that you're facing out there. And they're not all that uncommon. We have more than 7,000 public drinking water systems in Texas. Many people served by smaller systems. In your case, you're really relying on a neighbor's water treatment facility, and I appreciate that the challenges are big. I did want to point out to you, Mayor Moffitt, that and I don't think you need it for this case, but in the future we do have a small business and local government assistance program. So if you or anybody in the city runs into problems, really any questions about regulatory compliance, stuff that relates to TCEQ, get in touch with us because we have staff that are part of that assistance program that are there to help you and other local governments and small businesses. I just wanted to point out that that's available. And then specifically with request. Okay, go ahead, sir.
You wouldn't have a phone number, would you?
Well, I bet you. I'm going to keep talking for a little bit and let staff dig up a telephone number for you, and then we'll have them read it to you in just a minute. So, Ms. Cordell, if I could impose on you, or if I could impose on any staff that's listening to send Ms. Cordell the phone number, or maybe one of my colleagues can look it up real quick. But we'll get you that number before we finish up. The other thing, that's probably another phone number for you. But we have a team of technical experts. We call them our TOPS team, that works specifically on public drinking water systems. So if you have a challenge getting the drinking water right, or if the city of Strawn does, we do have some technical resources here that we can offer some assistance that way too. I wish we had more of them. I think we've actually asked the legislature for more of them because they're spread thin, but they're really good too. So, Ms. Cordell, did anybody send you a phone number by any chance?
I'm savvy on the website. So our website shows 1-800-447-2827.
You want to repeat that for Mayor Moffitt?
Yes, 1-800-447-2827.
All right, thank you.
We have a website as well, and so you can find that off of our TCEQ site. But we can also contact you and follow up after this agenda.
All right.
If you like, or would you like us to give you a call, or you want to just keep the number handy and get in touch with us?
Actually, I think I'll just keep it handy because we're hoping that if it happens again, the chlorine injection will cure our part of it.
Right.
And then too, later in the summer when it gets hot, our line's about 5 miles, so the chlorine tends to drop out, and sometimes we're bumping low chlorine anyway. So that's that's why we're putting it in. But no, hopefully this will fix this.
Good deal. Well, we're here to help you if you need help. Just let us know. Probably the best point of contact is that Small Business and Local Government Assistance Program. And then if it relates to drinking water specifically, they can put you in touch with our TOPS team. But I'm sympathetic that you're a man who wears a lot of hats, and being mayor means a lot of things in a small town, and it's a challenging position. But I appreciate you, especially on drinking water, working so hard to get this right.
All right. Well, thank you.
Thank you very much, Mayor Moffitt. Ms. Smith, is there anyone signed in to speak on the enforcement items?
No one else has signed in to speak on enforcement.
Okay, thank you. Let's hear next from Public Interest Counsel.
My office reviewed these items, and we recommend approval of the orders as presented by the Executive Director.
Thank you, Ms. McWhorter. I agree. I've reviewed these items and think we should go ahead with approval. Commissioner Lindley, any additional thoughts?
No, I'm in agreement.
Commissioner Janeka?
I'm in full agreement as well, and I only want to add on my warm regards about the exchange that we had with Mayor Moffitt and the city of Mingus. I think if all of our respondents in the state of Texas were as forthcoming and willing and quick to try to rectify the circumstances they find themselves in with our agency, I don't think we would have nearly as much work as we do. So I really do appreciate y'all doing the ever difficult work to keep up and abreast with our technical requirements. So thank you.
Thank you, Commissioner Janeka. I think we're ready to hear a motion.
I will move that we adopt items 9 through 20 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 21 is our public comment session. We don't currently have anyone signed in to speak on this item, but we can pause for a moment to allow anyone to speak up if they would like to talk.
Thank you. So we'll unmute the line, and if anybody's on the line that wants to make a public comment, you can please identify yourself.
Well, it appears that we don't have anyone signed in or interested in speaking, so that brings us to the items posted for closed session, items 22 through 25. The Commission will not meet in closed session today.
So colleagues, with that, the time is 11:40 a.m. and we are adjourned.